Hello everyone, this is going to be a YouTube video just explaining what we went over in class today, because actually today and yesterday, only because I did not hit the record button. My mistake, 100% my mistake. And so I will make sure to record later. So these are for students that were unable to attend the in-person class and wanted to watch recordings. So these are the links. If you attended the in-person class and you know what to do, you're good. So we were talking a little bit about the judicial branch today, and we talked a little bit about the judicial branch yesterday. I was probably a little bit unclear yesterday because I was in a room that felt like 100 degrees. I am back on campus, and all of the beauty and wonder that is Idea San Benito has certainly been creeping up on me. But the AC is finally working, and that's all we need to be good teachers. Well, actually, no, we need a lot more than that to be good teachers, but that was a very necessary requirement for me yesterday. So we're talking about the judicial branch. Here you can see my freshman 15 days. Everyone gets freshman 15. Yes, that was a freshman 15 days. Unfortunately, but there I am before the Supreme Court. There's this beautiful line, equal justice under the law, enshrined in the Supreme Court. And I will say that one of my students, Angel, did remind me of the Breonna Taylor case, and it's very interesting how we sometimes adopt different types of language, legalistic language without knowing it. But there was a lot of people saying that equal justice was not applied in the decision to charge only one officer in the Breonna Taylor case. And I think that's such an interesting thing to say. So I'll include links in this video description to make this extra useful for me and you if you're rewatching it. But I'll include a link to a great feature on Breonna Taylor in the New York Times. So remember, you have to take basically Cornell Note questions and answer these Cornell Note questions. If I highlight them in purple, you have to give me the answer. I'll pick up the notebook in 2 weeks. So we talked about the vagueness of Article 3 of the United States Constitution. So in particular, Article 3 of the Constitution is right here. It sets up the judicial branch. It says the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The judges both of the Supreme and inferior courts shall hold their offices during good behavior and shall at stated times receive their services compensation, which shall not be diminished during their continuance in office. So Article 1 sets up the legislative branch, Article 2 sets up the executive branch, and Article 3 sets up the judicial branch of government. And we said that, or I said that it kind of reminds me a lot of your essays sometimes when you're like an afterthought. And in some ways, the judicial branch was not unimportant. It was still a co-equal branch of government, right? That was supposedly embedded in the system of checks and balances articulated in Federalist 51 that were essential for a non-tyrannical government, non-tyrannical federal government. But I will say that the judicial branch certainly has expanded in power since its inception in 1787. So it says here they're vested in one Supreme Court. That's the only court that's set up by the Constitution, but it also gives power for Congress to set up inferior courts, which they certainly did with the Judiciary Act in 1789 and subsequent modifications to that. Yeah, so we said we'll talk about original jurisdiction next week and appellate jurisdiction. Okay, cool. So then we discussed this hierarchical system of the federal judiciary, district courts at the bottom where there are trial courts. We discussed the difference between civil and criminal cases. I'll include a link in the description to discuss that difference further. We said that if you don't like the decision, any party in those cases can appeal the decision in the courts of appeals, courts of appeal often called circuit courts. and then you can appeal that further to the Supreme Court of the United States. But we also watched that Fox video where we said, like, people claiming that they're going to take it to the Supreme Court. That's really a super big American misconception. You have really Supreme Court justices get about 10,000 appeals, and they grant about 100 of them. They only hear about a significantly small percentage of cases. Hear from a significantly small percentage of cases. We discussed Federalist 78. We read Federalist 78, or the excerpt from Federalist 78 here. We talked about Federalist 78 written by Alexander Hamilton. So Hamilton says the judiciary will always be the least dangerous to the political rights of the Constitution because it will be least in the capacity to annoy or injure them, since it has no influence of either the sword or the purse. No legislative act contrary to the Constitution can be valid. To deny this would be to affirm that the deputy is greater than his principal, the servant is above his master, that the representatives of the people are superior to the people themselves. The Constitution is, in fact, and must be regarded by the judges as a fundamental law. It therefore belongs to them to ascertain its meaning, as well as the meaning of any particular act proceeding from the legislative body. The independence of the judges may be an essential safeguard against the effects of occasional ill humors in society. These sometimes extend no farther than to the injury or to the private rights of particular classes of citizens by unjust and partial laws. That inflexible and uniform adherence to the rights of the Constitution and of individuals, which we perceive to be indispensable in the courts of justice, can certainly not be expected from judges who hold their offices by temporary commission. So there's a lot here, and I read it in its entirety. I don't know why specifically, but this is a really cool phrase. Hamilton says that the judiciary is supposed to be the least dangerous branch to the political rights of the Constitution because it will be least in capacity to annoy or injure them. Says no influence of either the sword or the purse. And so the sword is kind of like a metaphor for the executive branch. We discussed how the executive branch is the one that enforces the law. They're the one currently that oversees the FBI. The president is commander-in-chief of the military. So very much the sword. And then the purse is an important power granted to Congress. Congress has the right to raise taxes and allocate spending to for the government itself. And the judicial branch really has none of those things. And so Hamilton says or speculates that the judicial branch is going to be the one least susceptible to tyranny because it really doesn't have this enforcement mechanism. And so the question is, what creates this enforcement mechanism? What creates this enforcement mechanism? Or this ability to, what creates, or another way I should frame the question, or another way I want to frame the question, because next week we're going to be talking about the impending Supreme Court fight over Ruth Bader Ginsburg's former seat, Justice Ginsburg's former seat, I should say. Give Justice Ginsburg the respect she certainly deserves. But why is there a fight? Why is this of such national importance, right? Why is the Supreme Court so important today? And that's what I want you to have in the back of your mind, right? It doesn't really have this enforcement, or it might have enforcement power, and we'll talk about it, but that power may not be as tangible. Obviously, the justices are not commander-in-chiefs of the military, and they don't necessarily oversee the FBI, but somehow their rulings and opinions matter in our society and can affect those institutions themselves. So the argument I will make, I'm not going to keep you in suspense, is an argument about culture, it's an argument about norms, it's an argument about the importance of rules, formal and informal. Also, something that Hamilton makes in this piece particularly, he talks about the independence of judges themselves as an important safeguard against the effects of occasional ill humors in society, and he kind of advocates for a permanent appointment to judges, as opposed to legislators that in Congress that are seeking re-election every 2 years, and senators that are seeking re-election every 6 years, or I should say legislatures in the House of Representatives seeking re-election every 2 years. he supports a judiciary appointment for life. And he claims that this is going to be good because if there's like super radical changes in America's political climate or culture, the judiciary is going to be resistant to that because they are lifetime appointees. And I think there is some truth to this, right? And I think right now, too, we also have to remember that Hamilton is making a value judgment, right? Some of us, no doubt, would very much be angered by a judiciary or seem like the judiciary is unresponsive to the will, the democratic will of the American people. We'll look at some pretty controversial rulings next week. And so maybe you really don't like this idea that the judiciary should be permanent and resisting to the changing whims of the people in some ways. But like I discussed earlier, our political system is very much designed to prevent radical shifts. There's this great quote that Ruth Bader Ginsburg paraphrased from someone else that was in a Times profile that I'll include in the description below, where she says, she talks about a pendulum, that the great symbol of the United States is not the bald eagle, it's the pendulum, because whenever something swings too far in one direction, it'll eventually swing back, right? Our system is designed in some respects for the prevention or even the watering down of attempts to radically change society, whether we like it or not. And the question is it even effective at doing that? That's the question too. Many philosophical questions. What do judges consider? So judges consider all kinds of things. They consider court precedent in their judicial rulings. So has the court answered this question before? And if the court has answered this question before, that informs some of their application of the law, the way that they interpret the law and the way that they apply federal law. The Supreme Court makes federal law for the land, or doesn't make federal law for the land. I'm saying like the Supreme Court's opinion about federal law of the land sets an important standard and has an important effect on this country as a whole. So if ever there's discrepancies about federal law at specific courts of appeal, the Supreme Court steps in and can or has an application and interpretation of that law that makes that debate no longer a debate. So for example, there was a debate in the Supreme Court ruling, which we'll untangle next week, about gay marriage, where there was different courts of appeal that had different positions on gay marriage. One saying that it was violative of the Constitution to prevent same-sex couples from getting married. Another court of appeal saying that it was not violative of the Constitution. The Supreme Court saying it is violative of the Constitution, and effectively rendering that debate moot and making gay marriage the law of the land, as they did in an important Supreme Court case, which we'll talk about next week. Empirical facts. What's the impact of this decision? They'll also consider that as well. So this was the Supreme Court. The most recent photo, obviously Justice Ginsburg, the liberal justice, passed away recently. And here are the justices. This is Neil Gorsuch, Elena Kagan. Oh my goodness, no, I can't believe I'm blanking. Sonia Sotomayor, Clarence Thomas, Justice Breyer, Justice Roberts, Justice Kavanaugh. Oh my goodness, I hope none of my former colleagues or Georgetown friends are watching this because I'm blanking on him. I am blanking on him. I want to say Alito. Yeah, Alito, I think. Okay. So these are other things justices consider. They consider historical interpretation. Go ahead and look through this list. I'm not going to spend a lot of time reading it. Textual interpretation, structural interpretation, doctrinal interpretation, ethical interpretation, and prudential interpretation. Next week, we're going to get at conservative jurisprudence, or like legal philosophy, the way conservative justices, quote unquote, interpret and apply the law. and often are seen to interpret and apply the law in ways that people that are politically conservative want, and the way liberal justices traditionally interpret or apply the law, and are often seen to be ways that people that are politically liberal want. So we'll talk about originalism and this idea of the Constitution as a living document and all these different types of things. I've also included a transcript to a Brookings event. I love the Brookings Institution. It was one of my favorite things to do, was go to the Brookings Institution, have some coffee and bread, and watch people a lot smarter than me talk about issues in DC. But it does not have a video because it's an older Brookings event from 2009, but it talks about like conservative legal philosophy and how liberals kind of have an amorphous legal philosophy, and how they would probably be better served if they were better at defining their legal philosophy. Next week. Or in the description, I'll include it in the description, but it's a transcript. We talked about Marbury versus Madison. I'll include a link in the description. And judicial review. We'll talk about judicial review next week. Or we'll talk, I paused for a bit because I'm hearing noises. I don't know if you can pick this up, but like my room is like very loud. But Marbury versus Madison, judicial review, we're not going to talk about next week. We talked about it this week. Judicial review's ability to declare a legislative act or executive branch action void. It's an incredibly important power that the Supreme Court has and that the judiciary has, right? They can say, okay, that act is unconstitutional, you need to stop, right? And the question is, how does this branch, which is not, the justices are not commander-in-chief of the military, like let's say the Supreme Court is the one that says this, how does this branch impact the executive branch or laws? How does it render stuff void and say like this cannot be done? Like how does it enforce that? So we went into the Youngston Sheet and Tube Company versus Sawyer case. What would happen if Truman told the military not to obey in this case? So we discussed this in detail. We watched the video. We said the Supreme Court would Truman nationalized steel mills. That's a hard word for me to say for whatever reason, because steel workers were on strike or planning to go on strike, so he decided to nationalize steel mills. He informed Congress he was going to do this, but Congress never passed a law giving him the authority to do this. So he nationalized steel mills. The Supreme Court ruled that this nationalization of steel mills, Truman nationalized steel mills because the workers were planning on going on strike. This was a time of war. So Truman cited, I'm commander-in-chief of the military. He cited inherent powers, which we talked a lot about last week, which are super important, and that he has special emergency powers during time of war and conflict. And we found the court ruled 6-3 against Truman, saying he did not, in fact, have this power to do this. And then we asked ourselves, what actually was the impetus? What was actually the impetus behind Truman's decision to tell the military, okay, the Supreme Court is right, let us pull the troops away from the steel mills. I'm going to give them back. And then some of you said, well, maybe Truman was fearful of impeachment. And then some of you said maybe Truman was fearful of potentially going to jail. I was like, who would send him to jail? And some of you said, well, maybe Truman was fearful of the fact that the military would listen to the court and would not listen to Truman, right? And the answer is probably, I don't think Truman would have been impeached if he chose not to listen to the judicial branch. I think maybe the military, I don't know about the culture too, and so this is just kind of me presenting this case as an ideal typical case. I don't really want to entangle too much in like the history of it, but I'm not so sure that if Truman told the military to continue and maintain their seizure of the steel mills, that they would continue to do it, or that they wouldn't continue to do it. They might actually obey him. I think what really kind of allowed the court to have this force was that Truman himself realized and was a man of integrity, perhaps. And he realized that if he chose to tell the military not to enforce or not to listen to the Supreme Court's ruling, that would effectively mean that the Supreme Court has no credibility, has no power. And he probably could have still gotten his way by just ignoring the Supreme Court decision, but that would be bad for American democracy, a system in which there are checks and balances. And so Truman was probably very much socialized in this culture of, I have to listen to what the Supreme Court says. I have to do, or socialized in this political culture, socialized in this culture the importance of the rule of law, or at the very least socialized in the importance of Supreme Court decisions. But I think we can all imagine a president that would have done the opposite in this case, would have just said, ignore the Supreme Court. And that has happened historically. I'll include a link to the Supreme Court case in Worcester versus Georgia, with Andrew Jackson basically saying, the Supreme Court can issue its opinion, this is an apocryphal saying, that it's a paraphrasing, but let them try to enforce it. Supreme Court can issue their opinions, but let them try to enforce it. And so what I would argue is that American culture has a very strong norm towards following the law declared by the courts. But that norm changes through time. That norm isn't static, right? You can imagine in times of national emergency, like the Korean War, where another president could have made all the more difference and the court would have effectively been defied. In Andrew Jackson's case, no doubt racism and prejudice against Native Americans contributed to Andrew Jackson's willingness to defy the court, and the inability of other political actors and of the public to try to hold Jackson's feet to the fire, to obey the court's ruling. So the effectiveness of the Supreme Court is in fact a factor of American culture and respect for the rule of law. And this was something that was mentioned in Fromm's article that we read earlier, and that was an article that was incredibly critical of President Trump, that said, we only have rules and we need to follow them. We have precedents, we have norms, and we need to follow them. And a norm is kind of like an accepted standard or a way of being or doing things that most people agree with, usual, typical, or standard. Right? We not only have laws, we also have norms. Right? And one of the norms that is essential for a well-functioning American government is that the Supreme Court is the arbiter, is the interpreter of American law. And if the Supreme Court says something is unconstitutional, then it is unconstitutional, is therefore void. But I would argue this norm hasn't always been present. It hasn't always been robust in American history, as it might be presently, and there's no guarantee that it will continue to persist. And I would say that I'm just going to flag for you this Supreme Court fight over Justice Ginsburg's seat, which is something that we'll go over next week, presents a very real challenge. There's talks of court packing, and we'll talk about what it means to pack the Supreme Court next week. There's also talk of Republican hypocrisy, of claiming that it was not okay to nominate a Supreme Court justice in an election year, and then planning and intending on doing that right now when President Trump faces a very viable possibility that he won't be reelected. And so what I would argue is that we're presented with a legitimacy crisis of the court. We're presented with a crisis of legitimacy confronting the court, and it's approaching, or a potential crisis of legitimacy that is confronting the court, and it's approaching. And we have to ask ourselves, what will be the impact of this? What will be the impact of this on our democracy? On a democracy that is a very legalistic democracy. On a democracy that values the rule of law. What will this mean for our culture with respect to the rule of law? Legitimacy is so important for the well-functioning of government. We discussed this at the very beginning when we talked about social contract. If a government is seen as illegitimate, you should expect violence or protests at the less extreme end, but you should expect some outrage of some sort. And so here are the words of from earlier: a constitutional regime, and remember, regime is the type of government that runs the country, is founded upon the shared belief that the most important fundamental commitment of the political system is to the rules. The rules matter more than the outcomes. It's because the rules matter most, and then he goes on, which we'll forget about later. But rules and norms matter for a well-functioning democracy, and we're headed for a no doubt controversial fight over the Supreme Court pick. And there are some that have alleged that norms have been shattered. And some are advocating for further norms to be shattered, for court packing, for increasing the number of Supreme Court justices. There is no set limit of Supreme Court justices in the Constitution, by the way. There's only 6, or there's 9 now, but that is a norm. There had been lower amounts before. But Democrats are advocating for increasing the number of Supreme Court justices to counteract Republican stealing of seats. So that is something we definitely have to consider.